Hi and welcome back to another episode of To Me Mailbag. I'm Ben.
And I'm Andrea.
And this week we answer 5 questions about shareholders agreements. As with every week, the names are made up, but the problems are not, and they're based on things that we see in practice every single day of the week. And a quick legal disclaimer, just so we're clear, nothing in this video or in any of the videos that we do is to be taken as legal advice. It's the things that we talk about are general in nature. If you do have a legal problem and you do need to seek legal advice about it, then get that legal advice from a professional. Into the show. So our first question comes from Jake the plumber. He runs a trade business with 2 mates. The question goes, we started a plumbing business 3 years ago, me and my 2 mates from the tools. Business is going well, turning over about $3 million annually. The problem is I want out. I've got an opportunity, I'm gonna start again. We started a plumbing business 3 years ago, me and my 2 mates from the tools. Business is going well, turning over about $3 million. The problem is I want out. I've got an opportunity to go do something else. But when I looked at our shareholder agreement, it says that I can't sell my shares to anyone without the other 2 agreeing, and they have to match any outside offer first. They don't want to buy me out and they won't approve anybody else. I feel trapped. Am I stuck? This is a very common problem that we often see. And I think probably one of the starting points for the discussion that we're going to have here about shareholders agreements is shareholders agreements are critical, but there's nothing necessarily magical about any type of shareholders agreement. Getting a shareholders agreement that does the job that you want it to do involves careful consideration when you're entering into it about the various different scenarios that can present themselves. Things that we're going to talk about now that would be good if they were in the shareholders agreement they had that would help Jake also might give his business partners the opportunity to get out in circumstances where he doesn't want them to. So I think dealing with this question, we're going to, when he says I've got the opportunity to go and do something else, I think to make it simpler, we're going to assume that the something else is something that doesn't at all compete with the plumbing business. So Jake's got the opportunity to go and be a professional tennis player. And not a plumber, which wouldn't be in competition with the plumbing business. So we've got a situation where we've got, they've got an opportunity to match any outside offer, and they've got to consent to anyone coming in that he might sell to. Am I trapped? Sort of, a little bit. If not legally, then possibly commercially. How do you unpack this with Jake?
Yeah, look, I think the obvious issue is that this shareholder agreement didn't consider all the various, scenarios which could unfold if there was a disagreement between what are essentially business partners, and they've obviously opted for a company structure for whatever reason. So in that scenario, shareholders are bound by if there's a constitution, the Corporations Act, obviously, and if they're lucky, they've got a shareholders agreement. But if they're unlucky, the shareholders agreement is poorly drafted and doesn't consider these things. So as you said, first of all, reading the shareholders agreement and properly interpreting it is important. If he thinks that he doesn't have the ability to get out without the other 2 agreeing, get that verified.
So I guess that's more than a simple first right of refusal. It's common that you would see that there's a mechanism in a shareholders agreement where if someone wants to sell, they've got to offer it to the other parties first. I wonder if the shareholders agreement also has a mechanism in there to determine value. Look, if it's got these in there, it probably does. Whereby how it would ordinarily operate, you give them the opportunity, you tell them what the price is, or they tell you what their price is. If you can't agree on a price, there's a mechanism where, within a certain period of time, a valuer gets appointed. What the valuer, in certain instances, determines is binding on the parties, and then the shares are transferred for that amount. Here you've got the issue of there being a requirement that they consent to any transfer. I assume that what he's saying is that they don't want to buy me out and they won't approve anybody else. I don't assume anything is what the question actually says. They don't want to buy him for $1. And they won't approve anybody else. I think when he asks, am I stuck? He's potentially not stuck, because if the shareholders agreement doesn't require that he remain employed in the business, and we're going to talk about this in the next question, then he can stop working.
Yeah, and look, I was going to say, when you've got a deadlock like this, this is a typical fracture of the relationship, which is going to lead to other things which may actually entitle one of the parties to make some sort of claim for shareholder oppression.
Yeah.
So as you said, if he decides, well, if you're not going to let me out, I'm just going to stop working in the business and I'm going to just collect my dividends, then they may very well have a reason to try and kick him out using whatever mechanism they can through, which is available under the Corporations Act. And likewise, if they are, perhaps blocking him from attending directors' meetings or doing anything of that sort, he may have a claim for shareholder oppression. And if his money is tied up in an investment in this company and the terms of the shareholder agreement are actually preventing him from unlocking that investment in a way which is unfair or oppressive, then the court may intervene and actually make orders forcing the parties to sell.
Yeah.
And that process would entail the appointment of a valuer and all of that sort of thing to make sure that it is
For lack of
objectively
value.
fair.
Yeah. I think you're right in that when this stuff's going on, there is usually other stuff going on as well. And you look at the other stuff to see where there are points where you can build leverage to try to get an outcome for him. So ultimately, with a case like this for Jake, what Jake is trying to achieve is he's trying to realise market value for the shares that he's got in this entity. The shareholders agreement doesn't provide a clean mechanism for him to achieve that, but by creating leverage, and creating that leverage might be by, well, it doesn't say I can't stop working in the business, or if it does say I have to keep working in the business, the consequence for him ceasing to work in the business might be that it's an event of default, and that gives them the opportunity to buy him out, which they don't want to do anyway. So the consequence is sort of not there if they're not going to buy him out. So that would then sort of put the ball on their racket in the sense, hey, tennis analogy, he's going to play tennis. I didn't even mean that. Put the ball on their racket, and sort of say, hey guys, what do you want to do about this? And they're in a situation where what they might do, they might be like, well, we'll remove him as a director, or he might resign as a director. Obviously, you'd be giving him advice about the risks of not being a director, also the risks of being a director of a company you're not involved in on a day-to-day basis, but they might remove him as a director and they might jack their salaries up and be like, well, if he's not working in the business, we don't want him to get a dividend. And then there you might have your oppression action where they're paying themselves above market for what they're doing or whatever it might be. You also might have a situation where they're all paying themselves massively under market and this business doesn't actually make
an actual profit
if you were to normalise the earnings of the directors and they were just to be paid a market wage. So in which case, like, I'd argue the business probably isn't worth anything anyway.
Yeah.
So, but he didn't ask us about that.
All right.
What sort of provisions in a shareholder agreement? We get these problems that come to us, and you look at them and you've got to deal with what you've got. When we talk about shareholders agreements being a particular way, you look at like, well, geez, I'd love if there was certain ammo in this shareholders agreement. What would you like in that shareholders agreement if Jake came to you just to have that extra leverage without having to build it?
Yeah, I think having a policy on how to resolve a deadlock. You've obviously got three shareholders here, so it's probably unlikely, and 2/3 is going to get a majority. So there wouldn't be much that 2 out of 3 directors couldn't get past. But if it was a 50-50 business, then the resolving the deadlock, some sort of clause to resolve deadlocks would be useful. Having a mechanism for calculating the value is really useful as well. That because it's the type of thing that you're agreeing to before there's a dispute. Nobody's going to agree something they wouldn't want to be used against them. So it's generally going to be quite objectively fair.
If I was acting for the other guys, I suppose if you're acting for Jake, you would want there to be the preemptive rights are fine, and that's really normal. But here you've got, they don't want to buy him out, but they won't approve anybody else. You would need the ability to say, hey, look, I'll offer them to you first. I'll offer them to you at a predetermined rate or based on a predetermined methodology for valuing the shares. But if you don't buy them within a certain number of days or whatever, then I can go to the open market and sell them. I think the unfortunate reality for Jake is like, is there an open market?
Yeah.
So there's 3 mates in business together. Obviously we need to know more about the business to see, like, maybe he's got a buyer. Let's just say he wants to sell it to one of the employees. That could be what it is, because that actually, there could be a market for that. That's what you'd want. There's also the ability to have what's referred to as a Russian roulette clause in there, or a shotgun clause, where if Jake makes an offer to say, hey, I want to sell my shares to you for this amount, then they can say, well, look, I'll either buy them from you for that amount, or you have to buy my shares for that amount. What that doesn't help Jake with here is that it doesn't allow him to go and play tennis for a living. So the why shareholders agreements can be so complex to draft and so expensive isn't because the agreement in and of itself has some beautiful drafting in it or whatever it might be. As I said earlier, shareholders agreements as a document, as a creation, aren't remarkable. They either do a job or they don't. It's the working through all the various scenarios and figuring out what do you actually want it to look like. Because the things that we would love for Jake to have in this scenario are also things that at the start of it, Jake might have said, well, hang on, I don't want to be in business with some random.
Yeah.
So having some other mechanism in place that sort of gives you the comfort that you're able to get out of it in the event that you want to, or like you're comfortable if your business partners want to as well. So thanks for your question, Jake.
Sarah says, I started a marketing agency with my business partner 5 years ago. We both owned 50-50 and worked full-time in the business. About 18 months ago, she basically checked out, stopped coming in, stopped bringing in clients, but she's still drawing a salary and getting dividends. I'm doing 90% of the work. Our shareholder agreement says nothing about what happens if someone stops contributing. She won't resign. She won't sell. What are my options?
I mean, the first thing, let's just assume that there's an employment agreement. So they got
Yes.
the standard pack of employment agreements and shareholder agreement. Did she say that they have a shareholders agreement or not?
Yes, they've got a shareholders agreement.
But it says nothing about what happens if someone stops contributing. So cool.
Yeah.
They've got employment agreements, but the shareholders agreement doesn't say what it's supposed to say. Look, even in the absence of an employment agreement, if you're employed and you're getting paid to do something, if you disappear and stop doing the thing,
Yeah.
in most instances you can probably be terminated. So I wonder if she's also a director though. So
Yeah,
the issue that they've got here is they've got a deadlock. You were going to go at that.
Well, I presume that they're both directors as well.
They're
because,
50-50,
yeah,
they usually are.
You might need a resolution of both directors. This is going to come down to, I guess, what the Constitution says.
Yeah, the shareholders agreement might specifically provide for one of them to be a managing director, and Sarah might be the managing director, and she might be able to make hiring and firing calls.
Or there might be a casting vote, or, you know.
Probably not though. If it's 50-50, assume that the shareholders agreement, which has been a push button job, it's not properly considered.
Yeah.
All those sorts of things. It probably doesn't say anything. So I think what Sarah doesn't have a great deal available to her, and we'll talk in a minute about what we would like to have for Sarah in the event that she's there. So again, like with the previous question, and like with most of these cases where they don't have what you need in their shareholder agreements, you're looking at what can we do to create leverage here. So Sarah is the one doing the work that is enabling Cherie, or whatever we called her, to actually get the dividend. So if Sarah, what Sarah potentially needs to do is navigate the situation where Cherie understands that, well, hey, look, if you're not going to do any work, but still get half the money, and I'm going to do 90% of the work and only get half the money, then I'm just going to stop as well. So, and the situation there would be that Sarah can say, well, you're not working anymore, you don't care. And this wouldn't be specific advice that we would give in a meeting. We would need to look at things to see that Sarah wasn't breaching director's duties and that sort of thing. But if there is a world where if the business goes to nothing, then Sarah, because she's the one doing all the work and making all the money and whatever else, can pop up with a new business. This talk isn't about breach of director's duties or illegal phoenixing or anything like that. But if the business legitimately comes to an end, Sarah can then pop up once that's happened, potentially, and take the business. And creating that leverage is Cherie knowing that that's what Sarah intends doing.
Yeah.
And Sarah saying, hey, look, I'm just going to let it go into the toilet. So I can buy you out, but if you don't sell for a fair price, then this is what the world's going to look like.
And look, there might be some interim leverage, like that might be the end game. But if Sarah has the ability, and this all comes down to what's in, the Constitution and shareholders agreement, but can she put the dividends on pause? If they're being paid monthly, can we put them on pause until at least, the latest or the earliest that they have to actually do something with those dividends, and that might actually, stop a supply of money going to the business partner, which could be used to fuel a dispute.
The other thing you'd look at obviously is also what creating the deadlock and the stalemate around the termination of her employment. Obviously, she's got a conflict. Her Cherie, as a director of the company, not agreeing for her termination to be affected by the company. Essentially, she's taking money for doing nothing. That's not in the best interest of the company. That would be a breach of a director's duties. Without getting super deep in it, the option may be to go to the court to apply for relief there. Whether you actually do that or not, it's a commercial consideration that can get very, very expensive. If the business is worth plenty, then that is fine. But it's where the business is. I mean, she doesn't give us any information about how big the business is or whatever it might be. But if it was smaller, then spending 50 to get it to one appearance potentially in an oppression or similar claim might not be on the cards for her. But that could be the way that you create the leverage and say, hey, Cherie, not only am I going to torch this thing because if I'm working for you, I'm not going to work anymore and you can't make me work anymore. But also I'm going to apply to the court for an order that the deadlock be resolved by the court in that way, either a liquidator's appointed or whatever it might be.
Yeah, and you can actually apply to wind up a company on what's called just and equitable grounds, which is, there's this substratum of the partnership that is no longer there. We are no longer working in partnership. The company is in essence a partnership, and without that, it should be wound up and the parties should be, relieved of their obligations and be able to part ways.
Yeah.
And if it's a large company and there's, quite a bit of operating to do, you can even appoint a provisional liquidator to take over for the time being while the dispute's being worked out.
Getting to what we would like to have in this agreement, and this is a clear example of it, where you've got, and it's pretty common, you've got a provision in a shareholders agreement that says that 50-50 shareholding, if one of the shareholders ceases to be, or the nominated person for the shareholder, if it's a company or whatever, if they cease to be a contributing member of the company, if this person ceases to be an employee or they breach their employment agreement, it's terminated or whatever, then that is an event of default, which in this instance, Sarah can rely upon to compel Cherie to sell her shares to her.
Yeah.
Again, going back to the last question, what you're going to want in there is either a predetermined value, if that's what you want, or a predetermined methodology. If you don't have that, then at least a mechanism where, you make an offer and if it's knocked back, you get a valuer appointed, et cetera, and they make a determination. What you would also like if you're Sarah is, and this is super common, it's almost like an implied vendor. What isn't implied? It's express vendor terms, where if you engage in an act of default, you might be in bad lever, so they might be able to argue a discount there, which in this case, it potentially wouldn't be a penalty, so it would be upheld. And we will pay you off over 2 years or 3 years or whatever it might be. So essentially that puts the person in Sarah's shoes in a better position, because Sarah's immediately able to go, you've ceased to be a contributing shareholder, therefore under the shareholders agreement, I'm serving you with a notice of default. There might be an opportunity for Cherie to remedy the breach and come back in. Sarah probably doesn't want that, and that creates another issue. But then putting that into effect could then see Sarah with the company immediately and then be able to pay Cherie off over 2 years or 3 years or whatever.
Yeah.
That would be ideal. And that's pretty common, where you've got a small, I'm going to say a small shareholding as in a tight shareholding. It doesn't matter how big the business is, but where you've got a 50-50 shareholding and they've entered into it and they're both, it's intended that they both be operators in the business. It's pretty common for each of you to be required to be contributors to it. And then when you're going through the discussion at the outset about whether or not a clause like this should be included in there, then if Cherie says, well, no, actually, I only intend to be in this for 2 years and I'm going to bugger off, that might give Sarah some concerns about going into business with her. So,
yeah.
One
thing about the clause that triggers the ability to force someone to sell their shares is that it should objectively be clear what the trigger event is.
Yeah.
So you don't want to leave it to someone's subjective opinion about, oh, does that constitute a default or not? So making sure if you've got the opportunity to have this refined at the outset, that could be really critical, because then let's say the business partner says, oh no, I'm not in breach of my employment agreement. You haven't made that out. Therefore, any decision or any purported trigger event is not actually one, and I'm not actually required to sell my shares to you. So
100%.
just making sure that it's as black and white as possible.
Thanks very much for your question, Sarah. The next question is from Marcus, who has got a SaaS business and is looking to scale. Marcus says, we've built a SaaS product doing about $1.2 million in annual recurring revenue. My co-founder and I each own 50%. We've got an investor interested in putting in $500K for 20% of the company. My co-founder doesn't want to dilute. He reckons we should bootstrap. I think we need the capital to grow. Our shareholders agreement doesn't say anything about bringing in new investors or issuing new shares. Who gets the final say, and how do we protect ourselves if we do take our money? So Marcus sort of asks, well, not sort of, he definitely asked two questions here. It's firstly about who gets the final say on the raising of capital, and then how do we protect ourselves if we do take the money? They're very separate questions, and we can answer both of them. Who gets the final say on taking the capital? They're 50-50, so we'll assume that they are directors, and where the investor is only interested in investing on the basis that they get shares. I would say this is a situation absent anything in the shareholders agreement or the constitution where, unless you're unanimously agreeing, you can't issue new shares to somebody, so you can't take the money. You can take the money by way of a loan if you can enter into a loan agreement with this investor, that the investor, let's just assume for the purposes of the question that the investor is $500K for 20% and nothing else. So you both get the final say, because if you don't agree, you've got a deadlock and that's it. What we could do probably depends upon the position of the business. Where you say your business partner wants to bootstrap, you'd probably assume that you've got the ability to bootstrap. There is actually revenue there. You're making money, so you can reinvest that money in whatever further development of a product or marketing or whatever you're looking to do with the 500K that you want to bring in. I guess the difference between the two is about pace. So yeah, if you can't agree, then you sort of can't do it, and that's why it's critical for, particularly when we're talking to shareholders who, or business partners rather, who have got a high growth type of a business, where because of the nature of the business that it is, they're probably going to be looking for outside money at some point. It's critical that the shareholders agreement provides for how that money is able to be raised and what the intentions are and all those sorts of things, because often that's the death knell to a high growth business. It is a high growth business because it can't be any other business. If it doesn't invent this thing and take it to market and pump the right amount of money into it in order to achieve that scale, that's going to miss the boat. So
I think
that's
this is
critical.
just having from the outset a firm shareholder alliance on these topics, and making sure that both of the founders or whoever is brought in is actually has got the same risk profile. And, this has obviously got to a point because they haven't discussed this at the outset.
It'd be interesting to see the reasons why it's gotten here, because it could be making, obviously if we had bigger numbers, then it might be easier to tell what they were getting at. But it could be the case that if they don't get the 500, they might be making reasonable money based on what Marcus's business partner thinks. And Marcus's business partner is comfortable and he wants to keep, maybe they've declared dividends or whatever it might be. So
given that it needs to be, we presume it needs to be something that is unanimously agreed, there's going to have to be some compromise on both sides in order to reach some middle ground.
100%.
So whether that's, like you said, maybe taking out loan instead of equity, maybe making the amount smaller, maybe the founder that wants to use external funding gives away 20% of his or her shares, and that's the compromise. Whatever it may be, there's going to have to be some middle ground, otherwise it's not going to get through.
Getting to the next question of how do we protect ourselves if we do take the money, this is critical. So often companies who are raising money they're raising the money because they don't have any money, and they don't know what they don't know, and they don't think to go and see lawyers about what terms they should have in their shareholders agreement that they got with the new investor, or the funding agreement, whatever it might be, convertible notes, etc. And it's not usually, but it's potentially also the case that the person who's giving the money, because they've got the cash, they're a whole lot more sophisticated on this side of things. So we often see, and there's lots of stories about this happening, where an investor puts in some money and it's all on their terms. The founders, they're just looking for the cash. So they look at the cash, they ignore everything else, and you get these terms that are super damaging to the business. And then that investor, even though they've put the 500K in, they then stop the business from being able to be run. And you do see on occasion where the investor ultimately boots out the founders, because they've got that sort of a power. If they're only getting 20%, they might not. But the sorts of things where, that you'd want to be looking at if you do take the money, making it clear that, in the agreement, it's clear that the 500K is 500K. It's a capital injection. It's not a loan. If that's what the terms are, and then being really clear on what rights the investor has. If the investor is just giving you the money to allow you to do your thing, then you probably don't want them to be a director of the company. Maybe you would agree some corporate governance structure where they get, there's certain KPIs or whatever it might be, and they get monthly updates and management accounts and whatever, just to keep them happy that their investment's being looked after and they're not being frozen out of what's going on. Because that's also a risk, where they think that, because they're not seeing things, where they think that they're not being told things and they're worried about it, then they can go nuclear.
I think you have to assume that this, let's assume the worst, and the investor, isn't happy with the return on investment and wants out. What are they going to be doing to leverage the situation to their benefit? And those kind of things, like I said, I think in a previous session, if you have invested money, for a certain thing to happen with that money, and it doesn't happen, doesn't go to plan, that shareholder can apply to the court potentially for oppression and for, to have their investment returned, if depending on what the terms
Depending
are.
on what's happened, yeah.
I would say as well that you touched upon the, making sure that there's a governance structure. Let's presume that these co-founders have got a shareholders agreement that says every shareholder is entitled to appoint a director of their choosing. You don't want this investor coming in having that right. You probably want to set it up so that this investor has got a different class of shares that does not have, voting rights, the same rights as the founding shareholders and that type of thing. So founders' rights are important. And there are things that can be drafted around, for protection for that.
The risk being, if you don't have those things, then we spoke earlier about the founders getting booted, but also this investor, you might need to raise more money, and this investor might block that. They're like, I don't want my shares to be diluted. And the rational explanation of, if we don't raise this money, your shares are worth nothing anyway, because we can't turn this business into what we need to, that might not help. And then you've got an issue. Then they might turn it into a play where they know you need to raise the money, but they actually want to get their investment out because of outside things. And they're using this as leverage against you to try to get their investment out. So you've then got to go and find more than the money that you've already found. To be
I
able
think
to get rid
just
of them.
on that, when we talk about getting their investment out, we're not talking about taking their 500K out.
No,
it's
we're
not
talking
about
about selling their shares.
It's selling their shares based on the value of the shares. And if they got 20% of the shares, it's 20% of the value of the company. It's not, they don't get the money that they put in. It's, they bought 20% and they were going to cash in their 20% if that's the outcome. So
it could be that certain mechanisms can be built into the shareholders agreement, which gives certain milestones or the ability of the founders to acquire the shares back in the event that certain things are hit or not hit or whatever it might be, just so that again, it's going to come down to whether the investor who's putting $500,000 in is going to agree to it. So thanks very much for your question, Marcus.
Question 4 is from Tom. Tom says, my business partner died suddenly 6 months ago. We'd been running this construction supply business for 12 years. His wife has now inherited his shares and she wants to be involved in running the business, sitting in on meetings, questioning decisions. She's never worked in the industry what advice do we have for Tom? So Tom's got this issue. Let's presume that this company is owned with him and his now deceased business partner owning the shares in their personal capacities, and the deceased business partner's wife has inherited them through,
Yeah, they're distributed to her in that
estate or
way.
whatever. And there's no sort of other, company structure going on or trust structure.
And we'll assume that she was the executor of the estate and she chose to, rather than try to sell them, she chose to
keep them. Yeah.
keep them and put them in her name. She sort of can do what she wants. If she's
Yeah, I mean, if that's the simple structure of it, and that is the way, and this is all part of estate planning. You've got to think about what's going to happen with your companies when you're doing the estate planning. But as of right, she's entitled to those shares. And you'd look at the Constitution, any shareholders agreement, any other document of governance around this, and identify whether or not there is or perhaps there was the ability to use that event as something that triggers a share sale. But it's got this far now. So let's just talk about that type of clause.
I think you'd be assuming that it doesn't have that in there, and then getting to what you would need in there. So without that in there, you've got to try to make her an offer she can't refuse to get her out of the business. But I mean, you might not be able to. So you might be stuck with her as a business partner. The sorts of things that are common in shareholders agreements to deal with this are, it's commonly referred to as a buy-sell agreement, or you've got, an event of default is often what it's referred to in the agreement as, but not that anyone's in the wrong.
Like a trigger event.
Yeah, it's like a trigger event. Call it a trigger event for the purposes of this, where if someone is to pass away, then it gives the other partner the right to acquire their shares.
Yeah.
And again, going back to our other questions, usually if you've got a clause like this, you would want to also have how the price is determined, so either an actual value or a methodology that's to be employed in the event that it does happen. What you can also do is insure that
event.
That event. So the way that essentially works is that in the event that trigger occurs, then the insurance policy, and you need to speak to a broker about this and make sure that the policy does what it's supposed to do and all these sorts of things. And then if you're the business partner, making sure that you understand any exclusions or whatever it might be. But where that event occurs, ensuring that, what happens when the event occurs is that the insurance policy kicks in, and the policy on behalf of the deceased partner I'm going to say that again. The policy sort of on behalf of the partner acquiring the shares pays the amount to acquire the shares to the estate of the deceased, so that Tom in this instance is left as the sole owner of the business, but the estate of the business partner they get from the policy, they get the value of their shares in the business. So
no one's at a loss.
Yeah, because if you don't have that, then it might be all well and good to have a trigger event giving Tom the right to acquire the shares off the business partner who's passed away. But if Tom doesn't have the money, or the business partner or the business doesn't have the money to be able to fund it, then that doesn't help you. Then she comes in and goes, well, unless I come in and sit in this business, these shares are worth nothing because you can't give me any money for them. So having a policy in place that essentially pays for the transfer price is critical to ensuring that clause actually has the effect that you want it to have.
Yeah, and I think it should extend as well to TPD. And if you think about what kind of role you're in, not just TPD, but I don't know how to frame this actually. Not just TPD, but if someone is unable to perform their work
for medical reasons,
for medical reasons, and they might be able to do another kind of work, but just not continue in the type of work that they're doing, covering that as well. So now that Tom is in this situation, he's dealing with a shareholder who, we presume has a right to sit on the board and sit in meetings and be heard on decisions. So what do we say to Tom about that?
I mean, he hasn't told us yet that she's impossible. So she hasn't gotten there. He's concerned that she is. Yeah. I think the thing that I'd be doing immediately, and the cheapest thing to to do is to put a framework in place to help her not become impossible. Usually the things that cause people to behave in a certain way, I'm not going to say usually, sometimes, is them not knowing actually what's going on, not understanding it, and then being suspicious of what's going on. So the worst thing here would be that she thinks that, oh, Tom has been stealing money out of the company forever. So you would put in a governance structure where she didn't need to essentially do anything in the business, and she was able to continue to get dividends. But also Tom ran it in a way which was super transparent and kept her updated about what was going on. She might want to remain as director in the company, but obviously you're going to want her to not need to be, a co-signatory on bank accounts where Tom is just trying to pay the daily bills that come in and whatever else. But she might want to be on there for example, agreeing to transfers to the shareholders or to Tom or whatever it might be. So there's sorts of levers that you would pull there are like, giving her an allowance as a salary, like a director's fee or something. So she's getting a weekly amount, and then also ensuring that the dividend policy is clear and sustainable so that she knows that she's getting out of it what she wants to be getting out of it. I mean, part of that is understanding, like, you want to sit on the meetings, you want to question the decisions, like why.
Yeah. I think that when, let's say the company is, big enough to justify this, but if she is getting to the point that it's, difficult to manage her, perhaps you need an independent director to make it a 3-director.
Yeah. It could be someone from the industry.
Yeah, it could be someone from the industry. It could be a professional director, someone appointed just for certain, decisions to be made and just keep that governance in order. And that will sort of help keep things objective and in check. You've got an impartial person who's able to vote on decisions based on whatever the best case business case is, and not be, suspicious or have some personal, vendetta or whatever it is that's causing the issue.
And then also being comfortable with the risk that Tom can be outvoted by him or her and the business partner's wife. So
I think as well, it really depends on how carried away she gets. But we would even potentially look at rights to have her removed as a director through use of whatever means under the Corporations Act there is, or the shareholders agreement for that matter.
And even if you don't have a right to force her to sell to you, you can still try to buy her shares off her, and maybe it's worth giving her the Godfather offer and paying a little bit more than what the shares are worth, because that is going to be a better option than
and you make it back in the long run because you get 100% of the profits, which is good.
Thanks very much for your question, Tom.
Okay, this question is from Priya. Priya says, I want to give equity to 3 key employees who have been with me since the start. They took lower salaries to help build this thing, and I want to reward them and lock them in. My accountant said ESOPs and phantom equity, but I don't really understand the difference. I also don't want them having a vote on major business decisions. I just want them to share in the upside. How should I structure this, and what do I need to watch out for in my shareholder agreement? What do we tell Priya?
I think firstly, it's important to make really, really clear for the purposes of this video that we do not give tax advice, and anything involving the granting of shares in a company or anything connected with an ESOP or phantom equity or blah, 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 whatever it might be, there's always tax considerations for that, both for the employees and potentially the company as well. So whenever someone is getting advice about that, it needs to be sort of gotten at the same time as the tax advice, so you can look at the two bits and
it can also be really expensive to set up because of that overlay of all the tax advice and implications. So don't make the decision lightly to give away equity. And I would even say don't even mention it to the employees until you are absolutely
She already has. You can tell.
Oh, she didn't say that. But
she would have had a couple of beers at the startup function, and she would mention it to her.
I look, you might assume that she has, because they have taken lower salaries to help start the thing, and that often comes with, hey, if you come in, I'll put you on this low salary. Don't worry, you'll reap the benefits later.
Can we talk about estoppel claims here, or is that too deep?
No, it's not too deep. It's absolutely on point. So this is a classic example of what is an estoppel claim? What does that mean? That means that somebody has someone has made a promise that you will get something at some point in the future if you do X, Y, and Z. That person then relies on that promise, does X, Y, Z to their detriment. And then if you, as the person making the promise, don't hold true to that promise, that person has or may get relief from the court to essentially stop you from departing from the promise.
So force you here to give the shares, basically. So I mean, that she doesn't specifically say that that's happened, but it probably has. There's got to be a reason why they took under the odds, unless it was like some health tech startup and they had another interest in being involved in it because of what it was solving or whatever it might be, which may have happened. But I think the first thing that you'd be speaking to Priya about is like, what are you actually trying to achieve here? Because you might be able to achieve it in a much simpler, less intrusive way than granting these employee shares in the company. Or that might be exactly what you want. You might want them to participate in the uplift in the value of the company, and the only way that you're going to properly incentivize them for that is to have them be given shares in the company. Understanding that bit first then instructs what happens next. In an ESOP, or whether it's phantom equity or some sort of an arrangement where they either have equity or quasi-equity in the company, Priya needs to be really clear with herself, but also with them on what she wants them to participate in the increase in the value of the company. That's fine, but what role does she want them to have in the running of the company, and what role does she want them to have? What does she want the position to be in the event that they cease to be part of the company? Obviously, you can't force someone to continue working for you. So they're probably the two main things. There's obviously a whole lot of other things if you're dealing with an ESOP about, when shares vest, whether there's a certain cliff that they've got to get past before shares start to vest, and then what happens if they leave before a certain time, and all these fun things. The critical thing though is what percentage do you want to give them? What role do you want them to play in the running of the business?
Yeah.
And then what do you want to happen in the event that they are no longer part of the company? It could very well be that I want you to be here for a year and a half. And I know, given their specific skills in, just say, some tech thing, that I need their skills for the next year and a half. And then I'm happy for them to sit as a non-contributing shareholder or whatever it might be until we get an exit event. I'm happy for that. I'm just trying to lock them in for the year and a half. Critically, I think it depends on what they do. And also probably you'd unpack with Priya what roles these people are particularly playing. So it's critical to ensure that when she looks to get other investors, that anybody who is a shareholder in the company or is an employee who's been incentivized is actually contributing the value that is, commensurate with the interest that they've got in it. So if you're giving someone who's got a relatively low value contribution to the company shares in the company because they've been there forever and
you just want to keep them.
Yeah, you want to keep them. That might raise an issue where you've got, you're trying to raise money from investors, and the investors are like, if they were normal shareholders and it wasn't an ESOP or whatever, they look at, who's this guy that owns 5%?
Yeah.
That can be sort of where the company goes up in value. They've got an outweighed an ownership interest rather that outweighs the level of the contribution. So just getting really clear on what you're actually trying to achieve. It might be that there's also a lack of alignment between the employees and Priya on what they want. They might think shareholders, great, I'm a director.
Yeah.
And then Priya's like, no. The terms are that you get an interest in the company and you have absolutely no say in the company. And otherwise, you're putting your caravan on my car or truck or whatever, and I'm going to drive it. That's this deal. So it could be that in having those conversations, this probably comes into where a question is about phantom equity or quasi-equity or whatever. You could have an arrangement where they are incentivized either by KPIs that talk to the uplift in the value of the company or the actual value of the company. They are incentivized and get paid out a certain amount of money or something on an exit event or on money being raised at a certain level or whatever it might be. That might actually be what you want and what they want. and it might be the thing that sort of achieves that best. The critical thing is that you don't want a situation where it's not documented in a fulsome way, because there's, like you spoke earlier about the estoppel claim. That happens.
Yeah.
That's not made up. These questions are made up to protect the innocent, but that's not made up. That happens often. Well, I came in, you promised me X, Y, and Z. That's why I came in here at under the odds, and you need to now make good on your promise. So,
Yeah.
ensuring that it's clearly documented and you've taken both the legal and the tax advice to ensure that it actually achieves what you wanted to achieve, and there's no tax surprises or, control surprises or anything like that. That's critical. She's built this company. You want to make sure that you don't drop the bag, as they say.
Yep. I would also add, if you're, let's say you've got a scheme in place where certain employees are shareholders. While you may think that the terms or their rights arise from whatever that ESOP says, don't forget that they've got rights as a shareholder under the Corporations Act, which includes shareholder oppression. And that means that any decision which impacts that employee in their capacity as a shareholder has the ability to give rise to rights of that shareholder. So just warning about that.
Warning for prayer. Thanks very much for your question. That's the end of the show for this week. If any of this has hit close to home and you, like lots of people, haven't read your shareholders agreement since you signed it or aren't even sure if you've got one, then it's probably a good idea to go and figure that out. It might be that you're in a situation now where, even though the business has been running, you're in a good place. Potentially now's the right time to start having the discussion with your business partners about what you want the world to look like in the event that certain things happen. The unavoidable truth is that any shareholder dispute that doesn't have a shareholders agreement that clearly deals with a scenario is incredibly expensive, and any lawyer will tell you that. So thanks for tuning in. If you've got any questions you'd like us to answer, please drop them in the comments. Don't forget to like and subscribe. Until then, we'll see you next time.